I'm Steve Griesemer. I am the attorney representing Michael Cole, Joe Weingarten, and Glenn Brown on behalf of themselves and all other similarly situated residents of the town of Fishers. Given that Fishers is twice as big as any other town in Indiana, it's got 80,000 people, the petitioners felt that it was time to get a more representative form of government. So, exercising their First Amendment rights, they went out, they petitioned under a section of the law that says if the town officials won't change to a city, the individual voters can petition and hand in a petition that demands a referendum vote on city status. If that vote was successful, then they would change to a city, and that would allow them, under Indiana law, to directly elect a city council and directly elect their city mayor. And that's been the case since the late 1800s. A change in status from a town to a city would allow them to directly elect their city representatives, both the legislative and the... Well, 3 days after it was filed, the town passed a ordinance or a resolution declaring that they were entering into a reorganization process. And they thereafter claimed that because they were in reorganization, they could not put the citizens' petition on city status on the November ballot. They had about 6 months to do so, and they said, no, this will all be resolved through reorganization. And that resulted in the reorganization plan that is now the subject of litigation in federal court, which was adopted in December 20th, 2010. The reorganization plan under Indiana law allows them to restructure with Fall Creek Township to find financial savings, to make the government more efficient, and they've set forth a number of things within their plan that we have no objection to. But buried within the plan on page 8 and 9 are provisions that have nothing to do with financial efficiency or operational efficiency. They, unlike any other city in Indiana, have eliminated the citizens' right to vote for a mayor. They have eliminated the citizens' right to directly elect the city council. Instead, they say that the city council will be elected at large, and they will appoint a mayor of their own choosing, which mirrors exactly the town structure. So effectively, they say, here, you're getting your city, but you don't get any of the electoral rights that you petitioned for. So that's where the term sham city came from. The petitioners wanted a city. The fact that they're reorganizing into a city is great. What we object to is the notion that they're going to become a city without any of the voting rights. They will be operating the same way in one sense, which is when it came time to figuring out who would be the first members of the city council, they put in the plan that they would install themselves as the first incumbent members of the city council. And you know, it would be my hope that when the Indiana Supreme Court clarifies that the law says what it says, that cooler heads would prevail, and people would see that that this is probably not the way to go about reorganizing, that there are an infinite number of options, but eliminating the right to vote and piggybacking that on reorganization is not one of them. They have passed a resolution indicating that they are going to put both the petition clean option of do you just want to become a city and their option do you want to become a reorganized city on the same ballots to be voted on the same day in November 2012, which we have contended in our federal lawsuit is a very confusing choice for the town voters and is potentially designed to dilute support for either option, and if neither option get over 50%, then they just remain in town and say, well, all's well.